Ladies and gentlemen, may I have your attention, please? We are about to begin any time now. Out of respect for the proceedings, we seek your cooperation to maintain silence at all times. Switch off your mobile phones or keep them in silent. All rise. The People's Tribunal is now in session.
Good afternoon. I apologize that we kept you waiting. One of our members had just come from Indonesia and got here 5 minutes ago. We are glad to see so many people here. As you know, the purpose of this
allegations have been adequately made out based on the evidence presented, and secondly, to examine whether these are systemic and germane to the entire electoral process, or were they just some maladministration that occurred along the way. That will, of course, be for your honors to judge. We said that we will conduct this in the tranquil atmosphere, outside of the intense contestation and the wounded pride of protagonists. I think we have, I must say, done that. The general atmosphere has been extremely cordial, and we have been able to present our evidence and have matters clarified by your honors in quite a remarkably adequate way. We have presented evidence of 51 witnesses and presented 71 statutory declarations by the people of Malaysia. 5 days, of course, was not enough. It was packed, but with detailed analysis and information. I think we looked at it from the conceptual basis. We had experts. We looked at it from the measures, first few opening pages, what these principles and standards are. They are derived from 3 basic documents that have become accepted norms in all civilized democratic societies. And I invite your honors respectfully to look at bundle 4. There are 4 bundles of authorities. The leanest one is the 4th one. Registrar.
Okay.
So I draw on the first is, if you look at tab 2, this is a handbook prepared by the United Nations Center for Human Rights, based in Geneva, and it is entitled Human Rights and Elections. So that is one of the major sources of this presentation in part 1. Then I will also be referring to the first document, the first tab, which is a declaration, which is a document prepared by the Inter-Parliamentary to the will of the people and to the government itself, governmental authority itself. So it is an important, it's not the only step, but it is an important first step in the entire process of allowing a citizenry to decide upon the government of its choice. So it has to be exercised. It's not just a right in vacuum. It has to be exercised together with all the other rights: freedom of speech, freedom of expression, freedom of assembly, freedom of movement, and so on, and freedom from fear, from intimidation, etc. And the process, this freedom must also give rise to freedom to canvass, to educate voters, to have political meetings, rallies, and also, of course, a non-corrupt and non-partisan judicial procedures that can be accessed by those who are aggrieved by any irregularity that happens that is inflicted on them or on the process. And there must be equal participation. Now, at the bottom of my page, I say that when I talk a few components, I'll just quickly go through that because they are general principles. There must be runs the electoral process from bias or corruption. And it has, of course, above all, to act in a transparent manner. Then on the question of constituency delimitation, there must be fair constituency delimitation to reflect equal suffrage. We come then to registration of electors. It has to ensure fair process, to ensure fairness and effectiveness of provision. Basically, the whole process of registering electors must be done in a manner that places beyond question the integrity, for example, of the electoral roll. And the ballot itself, there must be means to prevent double voting. The means must be effective. The matters that relate to the reporting, the forms, etc., these must be beyond question, and the process must be protected from fraudulent or other intervention. There are other aspects there which I will not go into. Offences, of course, electoral law must provide to protect the political process from corruption and so on, and it must provide effective sanctions which are worked upon. And we will see later on whether this was in fact honored or honored in the breach. And media access regulation, I've already made some comments on that. And finally, we come to observation must be allowed, observers, and then we come to judicial adjudication of complaints. The UN handbook says any denial or violation of these rights and freedoms, any of these rights in relation to election, shall entitle the aggrieved person or persons to recourse to independent and impartial tribunals, including courts. So there must be adjudication. Where there is a grievance, there must be provided a remedy by an independent judiciary. And I'll submit on the facts in relation to this later. So this deals with the general principles within which we are functioning. We have these international norms and standards. Now, the witness, Dr. Wong Chin-hua, testified. He showed the malapportionment, which is disparity in electoral size, the size of electors, as well as gerrymandering, which is to manipulate the composition by moving around boundaries. Now, his conclusion was that there was a vote seat disproportionality for all parliamentary seats. You had PR is only 0.79% of BN votes. This means that the value of a vote for BN is 1.6 times the value of one vote for PR. This violates one elector equals one vote equals one value principle, which is a clash with the norms, the context in which I was talking about. Now, the malapportionment, there could be some justification. The malapportionment is done on the basis of weightage in favor of rural voters. But our witness, Mr. Wong, Mr. P.Y. Wong, showed that the factors that are identified as being relevant for purposes of determining and moving around voters count greater difficulty of reaching voters in the country districts and other disadvantages facing rural context. Now the point is this, there is no criteria by which to ascertain what is the level of weightage that can be given. Now that's the first point, because we are dealing here with laws that allow for manipulation. So that is the first major manipulation in the context of gerrymandering that can be undertaken and that is uncontrolled. So you have unbridled, unfettered discretion, and unfettered discretion is a contradiction in terms, because you cannot have unfettered discretion. There must be some limit to the way in which the discretion ought to be exercised.
When was this change made?
This was made in 1973. So this limitation was removed altogether in 1973.
And what was the justification given at that time for the...
There was no justification. They introduced the 13th schedule, Part 1, Section 2, and this was the provision that was then introduced. So there was no justification as such for this, but it has been progressified because there is this guide, and this guide provides for it. But the witness further demonstrated that even these criteria were not adhered to. Even this criteria of rural, semi-urban, and urban, because we had an example in Kedah, in a state for our international members of the panel. Kedah is a state right up in the north, on the west coast, second last sort of state up in the north. And it was shown by the witness that there are more between Baling, which is rural, with some element of urban maybe now, haven't been there for a long time, and Alustar, which is obviously at the metropolis, which is the capital. There is a speculation, there is an explanation. The only explanation for this, Baling Kedah, I'll supply a copy, I just was handed a copy just now. The only explanation is a political one. Baling is known to be an opposition. Oh, we have, is it? Okay. Oh, this is in orange bundle number 6.
Okay. Number 6.
This will be at page of that journal, page 14 of that journal. Constituency has 77,000 plus voters, while the average BN constituency has 46,000 plus voters based on the recent general election. In short, every PR parliamentarian has had to shake more hands and visit more farmer houses in order to win. And this person must know because he was one of the candidates. He actually won, so he knows how many hands he shook, much, much more. So with that, I just also want to have a caveat that he's a member of the opposition who has written this article. But all I'm doing is looking at the figures, which were attested to actually by Dr. Wong Chin Huat. And those figures are from this is the Barisan Nasional. The geographical drawing of boundaries defies logic. We had evidence that demonstrates, see slides 9 to 11, for example. We had situations where lines were drawn very arbitrarily, combining communities within the same municipal district, partitioning neighborhoods. One constituency has to go across through other constituencies where the matrimonial bed was divided into 2. And it was even suggested that the EC could perhaps be complicit in breaking up marriages and have their... So this was in Jamanta, for example, where Segamat and Sekejang, this was broken up. And we saw Mr. Ong himself, who said that his sister and brother-in-law could not walk hand in hand as they always did before that to go to the electoral poll. They had to part. And then we also had situations where the government promised one of the leaders of one of their smaller component parties. So this is the legal provision that we are talking about that has to be dealt with. The 13th schedule has to be changed if we want to put a stop to this kind of situations. And so we have suggested, in accordance with the mandate under the terms of reference that your honors have, that you would have to deal with reforms as well, not just to have a critique of what goes wrong or what could be improved. And therefore we have in the box that follows suggested institutional reforms as well as a reformation of the delineation process. And at our bottom, at our page 7, a certain fixed majority of votes which will allow for which must be implemented and should not be allowed to be manipulated so easily. And then it was also suggested perhaps you need state approval as well before you can have federal approval. These are matters for your honors to consider, because there is now beginning to emerge, and I say it without being partisan, there's beginning to emerge the shape of a two-party system, still at a nascent stage, beginning PhD students who traversed the country. We had him on video, if you would recall, because he was unable to be with us. He's gone to the US on a professorship, teaching professorship. And what all of them who were interviewed said, because they were aware of this 200,000, 100,000 limit, they said, no, we did not spend it, the agent did not spend it, it came from the party. So the formulation of this provision, when you say it's the candidate or his agent, is an open license to breach this particular provision, which is there to provide a level playing field. Dr. Chua Soy in the bowl, MCA president from 28 March, and he's the current president, and I think he's running again for presidency. MCA is a rich party because of the dividend that we receive from the start, which is about 50 to 60 million. That forms the basis of the funding, but it doesn't go to individual politicians. That money is party money. The party accounts are never tabled at party general elections. In all political parties in Malaysia, information is known only to top leaders. And then he says, the limit for candidates' election expenses is 200,000, but the official accounting does not reflect the true spending. Usually a candidate spends between 500,000 to 1 million for campaigning. And then overleaf the page, which I will quote in a different context, but I might as well read it. The government does favor the ruling parties, and he's part of the government. His party is part of the government. The government does favor the ruling parties through public resource usage, such as public employee deployment, use of government infrastructure, official advertising. So this is a clear, what we call in law, an admission against interest. He's suggesting that much more is spent. So you have a law that allows this to be abused. He has to fill out a form. And then when he was asked, what do we do about the auditing this? He said, no, we just have to rely on the honesty of the person who is submitting the form. So almost without fail, all these forms, I've been told, they are always within that limit by about $1 or $2.
There's never been a prosecution or...
There has never been a prosecution as yet.
And has this issue must be raised in many election petitions, I presume?
Yes, it has been raised in many election petitions as to the excess amounts, but the problem is proving that. Because they'll say, yes, this was spent, this advertising. We had the Member of Parliament, Puan Nurul Izzah, who came here and told us that excess amount, her statutory declaration, excess amount of advertising, this modern advertising, which as you pass by suddenly, before you know it, Raja Nongchik is rushing out to greet you or something from the billboard. So we had this at every flag post well before the elections, for example. But that's not accounted because the party has paid for it, so that's not part of it. That itself, I think, will cost a huge amount of money. So the way you can't catch me because they have not announced the date for the election, and he knows what the date is going to be because he's the one who ultimately is going to decide on dissolution of parliament, on giving a date for dissolution. And the date is fixed by the EC for the actual. So the other final point, of course, that was testified to by Terence Gomez, Professor Terence Gomez, is that there is no transparent disclosure as to the source of funds, and the playing field is not even. And he proposed actually a political parties act, perhaps drawing inspiration from an act of the same name that is in existence in the Republic of South Korea. Now, what we have done for purposes of suggesting reforms, we got 5 groups of reforms with regard to campaign financing, and we have placed that in the documents. So we have the purpose and methods of regulating campaign financing are set out by, we have suggested that the section in the Election Offences Act, Section 19, should be amended immediately. I believe there are some members of parliament in attendance here. It's heartening to see the people's representative coming to a people's tribunal, albeit in very small numbers, right? But it's good. And perhaps Section 19 of the Election Offences Act, which says that they are only going to limit a candidate, the expenses of a candidate and or his agent. This should be amended, and we have provided a formula to include any expenses incurred on what is wrong with our law. We have a Section 9A of the Elections Act, 1958. It prohibits challenge to the electoral roll once it has been certified and gazetted. And the High Court, we heard the very first witness, Charles Santiago. He said he filed a case in court, the number is set out here, and the court held that this section precludes any judicial review of the roll. There is an appeal pending. Now, a very critical facet of free and fair election is the integrity of the roll, because the roll decides who is going to choose the government of the day. And if that roll is defective, then the whole electoral process and the democratic process has been effectively subverted and undermined. So that's how important it is. Now, it says here, the UN standards say here, you must ensure fair process to ensure fairness and effectiveness of provisions concerning elector qualification, residence requirements, election lists and registers, and the means provided for challenging those documents. So ensure fair process, not only for undertaking the making of an electoral roll, but you must also roll, as disclosed in this trial, may be the tip of the iceberg. It could not be denied that the registration of voters in the LICA's electoral roll was in contravention of the law. No one, including the government department, is above the law. And if you look at page 410, it deals directly, right, the last paragraph, it deals directly with the electoral roll. And it says, if you're honest with me on this page, 410, right at the bottom, electoral roll. The gist of the petition is that the 1998 electoral roll for LICA's constituency was illegal, as it was compiled contrary to the constitution and laws of Malaysia. Only citizens are eligible to vote in any parliamentary election or state election of the federal constitution. And the electoral roll ought not to admit non-citizens or those persons who have been convicted of the offense of possession of fake identity cards. And then overleaf, the electoral roll for the country is updated annually by the Election Commission. Voters who have died are struck off and new eligible voters are added to the list. The election registration regulations, Sabah, 1971, we have 3 of these which are identical, Sabah, Sarawak, and West Malaysia, which sets out in a court of law for possession of fake identity cards. right? And then at page 414, it makes clear, the judge makes clear, 414, identity card not proof of citizenship. The identity card is not proof of citizenship. It appears that the Election Commission takes the identity card as proof of citizenship, and a person who produces a blue identity card will be registered in the electoral roll. Now, what happens then? All right? What happens then is that these concerns, which were highlighted by this case, instead of the Election Commission acting to ensure that the roll will be cleaned up, or the government of the day being concerned enough to realize that the whole democratic process was being undermined in this particular fashion, they pass an act in Parliament and says, in future, courts, you cannot look into this roll. Don't go and look and find out whether it's illegal or legal, and so on and so forth. So the integrity of the electoral roll cannot be excluded, can be effectively excluded, and those not included effectively join into the process. There have been many pronouncements that it's only when the battle lines are drawn that people begin to realize that there is something wrong when they want to go into campaigning and they go into houses and find suddenly those people who are listed cannot be found because the address is fictitious or there is no address, and so on and so forth, by which time it's too late.
May I just ask a question? If a blue IC cannot be taken as proof of citizenship, and birth certificate is also not proof of citizenship, then what is proof of citizenship?
The citizenship certificate and all other documents that relate to citizenship. For example, if you have a file, if you're born almost in pari materia, which means almost similar or identical to a similar provision under the Indian Representation of Peoples Act 1950. And this is section 30, which appears in bundle 4. Yes, it appears in bundle 4, the last tab, tab 8. And section 30, role for a constituency, or to question the legality of any action taken by or under the authority of an electoral registration officer, or of any decision given by any authority appointed under this act for the revision of any such rule. So he cannot, civil court cannot entertain or decide upon any question whether any person is or is not entitled to be registered. So he cannot question the electoral roll. Now this is, if you look at section 9A of the Election Offences Act, and this is in this blue book at page, no, it's under the
page 11.
Elections Act 1958. So it is page 11. So you will see here, after an electoral roll has been certified or recertified, as the case may be, so on and so forth, and gazetted, then 1, 2, 3, 4th line. The electoral roll shall be deemed to be final and binding and shall not be questioned or appealed against in or reviewed, quashed, or set aside by the court. So there is what they call in law an ouster. And I just read one small part, which is at page 427. And I invite, right at the last paragraph, it is of the essence of these elections that proper electoral rolls should be maintained. And in order that a proper electoral roll should be maintained, it is necessary that after the preparation of the electoral roll, opportunity should be given to the parties concerned to scrutinize whether the persons enrolled as electors possess the requisite qualifications. Opportunity should also be given for the revision of the electoral roll and for the adjudication of claims to be enrolled therein and entertaining objections to such enrollment. Unless this is done, the entire obligation cast upon the authorities holding the elections is not discharged. And the elections held on such imperfect electoral rolls would acquire no validity and would be liable to be challenged at the instance of the parties concerned. And then if we look at the case that follows, at page 429,
How does the court get around this very explicit language that it cannot be challenged?
view of administrative actions. And I will quote in a short while that this is how the law from England, India, everywhere has not allowed the executive to allow for ouster of jurisdiction in all affairs. And if we recall, in England itself, right, they started putting this provision at the early stages of the development of administrative law. They started putting this provision, ousting. Then the judges realized, judges used to uphold it, say, okay, this is a policy decision, it is best for the executive to decide this, the courts will lay off, and this provision says, please lay off. It's a policy decision. So they laid off. Then they found that in England, for example, they found that almost every facet of human activity of a citizen in England was being affected by administrative action. If you want to draw a pension, there was an administrative provision. There was an administrative provision in relating to that, with the ouster clause. Then when you wanted to lay any claim to all kinds of social and other services, right, to grants, to loans for jurisdiction. So this is how the balance between the various limbs of government, as it were, are maintained, so that when there is a citizen who is affected by acts of the executive, then the judiciary is the natural repository of functions for purposes of balancing this out. But if you have this 9A, Charles Santiago went to the court and said, look, this is going to happen and is happening in my constituency. They turned off and said, 9A, no, this is under appeal, so let's hope that some former student from the University of Malaya, where I teach law, is going to adjudicate this unaffected by any extraneous consideration.
Can 9A be interpreted in the same way as the Supreme Council interpreted it in India? Or is it not possible?
It is possible because we are talking about a same power. We all, India and Malaysia we are all based on the Westminster model, although we each have a constitution. We have separation of powers. The provisions are the same. The Representation of People Act, Section 30, is to bar civil courts. And this is how the Indian Supreme Court has dealt with this. And if you look at the
29, for example, and that's on page 9, 191, sorry.
Yes.
It says, inaccurate description of names and places. No misnomer or inaccurate description of any person or place named or described in any principal electoral roll or supplementary electoral roll or other document prepared or issued under or for the purposes of these regulations shall in any way affect the operation of these regulations as respects that person or place, if that person or place is designated in the principal electoral roll or the supplementary electoral roll or document as to be identifiable. It seems to me that, you know, if somebody looks at the electoral roll during that period and he finds that there are three names at one address, or the names do not contain exact information about that person,
Yes,
and makes an objection, that objection will be heard or by the adjudicating officer. Right? 2.
Yes, it's after the Likas case, 2001.
Yes.
So these regulations have been tweaked somewhat.
I'm not sure whether they have been tweaked or, you know, these are new regulations, and we know that there are some There's been a postal voting regulations, but we don't have, for example, advanced voting regulations. We only have guidelines.
Yes.
Yeah. So it would appear that you have to pay attention not just to the main provisions. You need to look into the details as well, because it seems like the devil is in the details.
It's in the detail. But at the end of the day then, the whole point is that, in fact, I come to it at my page 22, but at the end of the day, the whole point is, can you challenge the electoral roll? That's the point, you see. So if you have a 9A, and you're precluded from challenging it, then even as we saw manifest improprieties in the electoral roll, and the electoral EC itself says, no, I cannot do anything about it. If you want, and they are very generous about that, they say, please go to court. And you go to court, there's 9A. And then the judges, who then take a very narrow, restrictive view of 9A. That is a problem. So, and then it is concluded. So I agree entirely that it is at that stage also that certain changes would require to be made with regard to the objections. I've just been advised that regulations on objections is only on the supplementary role, because the main role has already been formulated, as we know, and then these are what we talk about, supplementary roles, which deal with revisions from time to time.
That makes it even worse.
That makes it even worse, yes.
Okay.
So here we go with the and then if you look at just one final point on this exact query that has been raised is bundle 3, the electoral roll on the basis of a wrong adjudication of this question of ordinary residence. So they say that in those cases, this gives an insight on this whole question of lack of power and when you can go into. And indeed, they deal with the NS-Minute case that I was talking about. And they go on to say, though the dividing line between lack of jurisdiction or power and erroneous exercise of it has become thin with the decision of the House of Lords in NS-Minute, we do not think that the distinction between the two has been completely wiped out. We are aware of the difficulty in formulating an exhaustive rule to tell when there is lack of power and when there is an erroneous exercise and so on and so forth. But just to summarize this aspect, all that they are saying is that where we can show that there is a lack of power, which means no jurisdiction, then you can go into the question. Then there is no ouster, in other words. And if we look at this final case, I want to cite very quickly at our bundle 2, at page 202. Voting the boxes that were kept. It seemed to be so also, right? It's very important. To inspire confidence in the minds of the electors that everything was above board. To ensure free and fair elections, the Constitution vests comprehensive responsibility in the Election Commission. The Election Commission, as part of fairness in election, has an obligation to see that no wrongdoer candidate benefits by his own wrong. The Election Commission, as a creature of the Constitution, has been invested with residuary power to be exercised in the infinite variety of situations that may emerge from time to time in the large democracy of ours, as every contingency cannot be foreseen or anticipated with precision. That maybe you can't raise it in an election petition. I don't know, I'm not so sure about that, but because there should be an open, since there is an opportunity now to open up and see the context within which 9A arose, even that should not be allowed, because this is an attempt to subvert, in my respectful submission, the whole democratic process of free and fair elections. Now, So then I want to quite quickly go on to page 11 of my submission and just very quickly refer to the fact that there are a mandatory rule, number one, and number two is to suggest to have an interpretation that is so narrow makes it doubly worse. And I have quoted there the case of Isaac Paul Ratnam against Law Society Singapore. I've cited the bundle, which talks about preemptory and directory. In the context of the Law Society of Singapore, a lawyer was disciplined, and he was talking about some of the rules. The question was, every rule that was stated there, the Law Society said is a mandatory provision. And the court said, no, you've got to look at the facts. You cannot really define beforehand what is directory and what is preemptory. You've got to look at the context. And you've got to decide, is it mandatory or is it directory? Organized. So here again, when we talk about amendments of the manipulation of legislation, this kind of adjudication process and the rules itself and the holding of these rules by the judiciary is something that has to be looked into for purposes of suggesting reform. Now we come to, I'm reminded that there is a lot to go and time is running quite fast. So let me also be a little fast. Now I turn to page 11. Now we deal here with manipulating the voters, which is preventing a voter's genuine preferences to be aired through a variety of manipulations. And the first, of course, is media bias, because it's unbalanced, it is inequitable media coverage. We had the SD39 at my page 12, Tessa. She analyzed one of the largest analysis of media, 28 media, print, mainstream, party link, TV, online, involves 17,000 articles, more than 4. There is a very interesting article called The Mind Rigging by Media, Electoral Offenses and Corrupt Practices. And at page 42, at page 42 and 43, Presses and Publications Act, then allow equal and free access to the public media for all interest groups. And there is also a memorandum that has been submitted to the Prime Minister in 2012, I believe, 2011, that we have made available in our bundle 4, which also deals with this question. I believe Bersih as well.
But if the parties are prohibited, if the parties are prohibited from media ownership, surely their friends will run newspapers which will do precisely the same.
And there is, on the left-hand side, a very clear pronouncement by the Sun newspaper, one of the leading journalists in the Sun newspaper, about this, on the question of media and integrity. So they have several proposals that relate to control of the media and delinking the media from political parties. So I think these are some of the proposals that we have set out. I have no time to delve into them in detail, except to flag them and provide those documents that we have provided. Now, advertisements also, and this article that I talked about, media rigging, also relates to advertisements. We know, for example, some of the leading newspapers, mainstream newspapers, published advertisements, took advertisements only from one side. And these advertisements we had demonstrated were not only just, but they were racially slanted, they were highly inflammatory in some case. And so the role of the EC and Press Council, the EC says they have no jurisdiction over this, but they do, because they have to prevent, they have to monitor Section 4A of the Election Offences Act, which says on the surface.
These are in our documents?
Sorry?
These
Yes, this is it's tied up with SD 47, Mas Zalija, and in her PowerPoint presentation. Then we talk about misuse of state resources for partisan purposes. I think I can do no better than quote what the president of MCA said. I just read it out just now. The government does favor, this at my page 13, the government does favor the ruling parties through public resource usage, such as public employee deployment, use of government infrastructure, official advertising, etc. So there you have it, you know, the coming out of the horse's mouth, although I don't know what sin the horse committed, why that we must associate with this man. So the thing is, I have set out here, at the top of the page 13, all these cases of use of public vehicles, government vehicles, buses, Mandip, Ko Junlin, Alfian Zohari, Ahmad Fahmi, and then we had, of course, To Kin Woon, the former state executive councillor. All this, just go back a bit. Just go back. This is open. This is the Deputy Prime Minister, presently also Deputy Prime Minister. 4 from the UK Cabinet Office. That's in our bundle 1. We just quickly do that. We have, we look at the practice. They have codes of conduct, general election guidance, bundle 1 at page 153. And this is for election campaign as to the conduct of all concerned and the use of government property. For example, at L, at page at page 192. Neither ministers nor any other parliamentary candidate should involve government establishment officers by visiting them for electioneering purposes and so on and so forth. And we also have the EC of India has established 2 model codes of conduct which are also available, bundle 1, I won't refer to them now. And then what should actually be done in other situations is also in a book called How India Votes, Election Laws, Practice and Procedure. The atrocious, scandalous report by the newspaper report by Raja Nongchik, one of the candidates, saying that if the opposition comes in, this change will usher in the kind of killing fields that we saw in Cambodia, and said this will be bad. This is how it got portrayed in the normal media, and you can imagine this kind of an impact. I mean, this is outrageous, being done with impunity, openly, by a minister of the government. So then we also had, at my page 14, racist slant to the campaigns. We had racist fear-mongering, and we had all kinds of situations, right? We had that this DAP racist, inflaming religious hatred, racial hatred, and this is by the this is really unacceptable. We don't have to go through this. Let's not inflame this. Take the slide out now. And then we had all this. Chai Yun-lung came, Lee King-tim came, Alfian Zori came. And very interestingly, Ideas, which is an observer of, accredited observer of the election, these kinds of matters, which are decried by 4A of the Election Offences Act, is really to undermine it in a very, very fundamental way, and this has to be stopped. And for the Election Commission to act, and for them to stand idly by while all this is being complained about and not do anything, is in fact doubly jeopardizing the nature of the elections. Perhaps at this stage we can have a short break, if possible.
You've been on your feet for 2 hours. Would you like a short break?
Yes, a short break, I think. I'm okay, but I'm thinking of you all, Your Honours.
We are seated.
I think maybe just to